Hello, welcome back to Legalize. I'm Shannon Gunn Emery, one of the lawyers with Gun Law Group. Today, we're talking about judicial review. Why the long face? Well, because if we're talking about judicial review, it's because you lost your Safe Roads appeal. At this point, you're not very happy. At this point, your lawyer is probably really unhappy too, because if we suggested that you go for the appeal, it's because we thought you had an argument. If when one of our lawyers looks over an IRS case and doesn't see anything, it is our office policy to have that case looked over by another one of our lawyers, just to make sure no one missed anything. So when we say we don't see anything, and we don't sugarcoat that, we will tell you that straight up, we are pretty sure there is nothing there. We don't leave any stones unturned. On the other hand, when we say go for it because you have defenses, that's because we expect to win. And when we don't, no one's happy. Even though it doesn't seem fair, and perhaps the decision is really stupid, but the reality is we had arguments and we lost. So now what can you do? There may still be hope. Also, you are definitely not alone. Very good lawyers are losing these every day, even though they had very good arguments. So even if you came from another firm and you felt, my lawyer must not have done a good job because I lost. No, they could have been brilliant. They could have had great arguments, and they could still lose. That sure doesn't feel good, does it? You may be wondering, why on earth would anyone appeal if people are losing every day with good arguments? Well, the first answer, obviously, is that some people are winning with those arguments, or with other very good arguments. In fact, lately, the win ratio has been pretty nice. Secondly, the law is getting better. And you know why? It's because of judicial review. That is how this system gets better, stronger, and ultimately fairer. So your first question is probably, what is judicial review? It is when a person goes to the Court of King's Bench to ask the court to review an administrative board's decision. It is like an appeal. We're asking the Court of King's Bench justice to look at the decision of the adjudicator and decide, was it reasonable? Unfortunately, we can't ask, was it right? Because they can get it wrong and it can still be okay. And you're thinking, what the heck? The adjudicator could have got it wrong and the Court of King's Bench is just going to say all good? Yeah. Unfortunately, sometimes, because the standard of review is reasonableness, not correctness. So the justice asks, was this reasonable, not was this right? I didn't make up the system, I just work with it. Safe Roads Alberta, which is the administrative board set up to look after impaired driving accusations like the ones we have now, is just the kind of administrative board whose decisions the Court of King's Bench will review. In December 2020, when this whole regime started and we had no judicial review decisions to guide those new adjudicators, well, let's just say that if you think the decisions aren't great now, you should have seen them then. Oh my heavens, it was horrible. And I told our clients at that time, the law is going to get better, but unfortunately not in time to help them. Those people who lost in 2020 and 2021 and who had the courage to go on to judicial review are the trailblazers. They're the ones who are making things better for everyone now. Okay, so the law is getting better, but really, you lost your IRS. Why do you want to go to judicial review? Because if you win, it's off of your driving abstract. I know it's not a criminal conviction, but it is on your abstract, so your insurance will not go up. You won't have to pay for ignition interlock a year, which is between $95 and $105 plus GST per month for rental after you pay about $700 to get the things set up. And you don't have to pay the $1,200 fine, and your seizure and your impound fees that you will have to pay to get your vehicle out of impound, well, that comes back to you. So there are a lot of pluses to going ahead with judicial review. So how do you get started on this great and wonderful process? If you've listened to some of our other podcasts, you know I am totally fine with sharing information about exactly how to do something. But if you're thinking of doing judicial review on your own, don't. It is just a minefield where you are going to get tripped up and you will not be able to do it well. And I'm sorry to give you no confidence on this, but really, you do need a lawyer for this one, or at minimum, a student, somebody who knows what they're doing. There are a whole bunch of forms that you have to fill out. If you don't file and serve all the right people within all the right timelines, your application is going to be struck and you will never even get to be heard by the Court of King's Bench Justice. As an aside, the most important deadline that you don't want to forget about is that you only have 30 days from the date that you got that horrible decision from the Safe Roads adjudicator to file for judicial review. And please, as your podcast lawyer today, please don't contact us on the 29th day and say that you want to file for judicial review, because that will put us into a tailspin and we will have to try to drop everything to try to draft, file, and serve everything in a day. Give us at least a week, please. These applications take a lot of time to put together properly. So now you're convinced, okay, I better get a lawyer, but then what will I have to do? Well, nothing. Unless you're looking for a license reinstatement pending review, in which case you will have to read over and eventually swear or affirm an affidavit that the lawyer drafts on your behalf. Other than that, it's a pretty simple process from the client's point of view. You pay your lawyer, and they do what they're supposed to do, and you just sit back and watch them do it. I'm sorry. Did I make that sound boring? Well, it is definitely not. I have one client who was bouncing up and down when she got her decision. So was I. Actually, we were all doing a very happy dance that day, and I'll tell you more about that case in a minute. You have to remember, we are actually making the law in this area that's going to govern for years. Where we are right now in Alberta is like the wild, wild west of impaired driving litigation in the administrative context. And we all know how much Albertans love the wild, wild west, or at least our version of it, with the pickup truck, the rifle in the back, the dog riding shotgun. Yep, we love the wild, wild west, and just think, your case could be the next legal spaghetti western of impaired driving in Alberta. I can already tell you the title. It's The Director of Safe Roads Alberta versus the Good Guys. That would be you. Now, as exciting as all this sounds, please don't expect things to go as quickly as they did in the IRS stage. Everything was so fast in the IRS, 7 days to appeal, 21 days they have to give you a hearing, 30 days you get a decision. Well, get ready for the slow ride. Judicial review, you have 30 days in which to start it, as I said, but then they won't give you a hearing for probably 14 to 16 months. I'm not kidding. And then the Court of King's Bench Justice will likely reserve his or her decision. What does that mean? It means they're going to take some time to think about it, and usually that some time to think about it is between 4 and 6 months. And you may be thinking, why can't they make a decision earlier? Remember where we are? Yes, the wild, wild west. They know every decision that they write is going to shape the law for years to come. They know every case is an important precedent. And so you're waiting and waiting, and you're thinking, well, what's the point then? If I got a 15-month license suspension, well, by the time I actually get a decision, the whole thing might be over. There may be some options for you. We might be able to look for license reinstatement pending review. That is a thing sometimes, but not always. Don't get your hopes up too much. Don't think that's a sure thing. Check with your lawyer and see what they have to say. If, on the other hand, you're one of the people who has a 39-month license suspension or a lifetime suspension, well, your suspensions aren't going to be up by the time you get the decision, and so you have really good reasons why you should be going for judicial review, even though it's going to take a long time. Another question you likely have is, what does judicial review look like? Is it like the IRS hearing? You might remember with the IRS hearing that we had an online hearing like Zoom or Teams, and you got to see that adjudicator who gave you the lousy decision, and you got to look them in the eye, but apparently they still came out with the lousy decision. Well, judicial review is a little different. It is likely going to be online, but you don't have to be there, and even if you are there, you don't get to say anything. No one is going to ask you any questions. It's the lawyer and judge show. Those are the only people who are talking, and they talk a lot. These are usually scheduled for a full day, and our clients are kind of like, really? A full day? Yes. Actually, the government just decided that they're only going to schedule these for a half day. But in my experience, these have gone almost all day, from 10 a.m. till about 3:30, sometimes 4:30 in the afternoon. They are a lot of work, not just that one day. The brief that we have to prepare takes a ton of time. I actually enjoy them, but they are very time-consuming and they have to be done well. We set out the facts of the case along with a description of the issues that we are going to be addressing in the judicial review, and then we set out what the law is and why the decision of the adjudicator just doesn't measure up. When the Court of King's Bench decides an adjudicator got it wrong, that helps other adjudicators understand, oh, I don't do that in the future. I do it the way the Court of King's Bench Justice told me to do it. And the law gets better. So do you see where I'm going with this? Yes, the law has only become better very slowly since December 2020. The proper interpretation of the Safe Roads Alberta Regulation, the Provincial Administrative Penalties Act, the Provincial Administrative Penalties Regulation, and the newer sections of the Traffic Safety Act have really only happened fairly recently. So I often tell clients, if you were stopped and all this happened to you 5 years from now, I would be able to give you a better idea of what your chances might be. But for now, it's still the wild, wild west. Every case that we take to judicial review has the potential to shape the law in this area in the future. So we take every case very seriously. Back to your situation. You lost your IRS appeal. You need to have a discussion with the lawyer about what are your chances of success on judicial review. At that discussion, your lawyer should be able to situate your case within the legal context going on at the time. So, for example, if the Court of King's Bench or the Court of Appeal has already heard or is about to hear a case that raises similar issues to those in your case, or maybe it's something more of a variation, that could have a big impact on whether or how you go ahead. The lawyer should be able to explain whether you have a novel argument or whether your case raises constitutional arguments where a constitutional notice may be required. So it's important to have a meeting with your lawyer early, and it's important to retain the lawyer in enough time to allow them to do all of the paperwork that they need to do to get that prepared. Another factor that your lawyer will go over with you is cost, because the judicial review costs a lot more than the IRS did. Sorry, but it's a lot of work. However, there may be some glimmers of light on the horizon here. First of all, you don't have to stay with the same lawyer that did the IRS appeal, so you may want to go up or down in experience level, which will also mean that you are going up or down in price. But secondly, you may not have to pay the whole thing. Now, I am not suggesting there that you hire your lawyer and then not pay them. That is a big no-no. No, I have a different solution for not having to pay the full amount. As we said, the law is changing every single day. Some cases have issues in common. So, for example, there was an issue concerning authentication of photographs. We argued unsuccessfully every single time in front of the Safe Roads adjudicators that, according to the legislation, there had to be a statement saying by the police that they had not altered any of the photographs, etc., and that they had signed the photographs. Then, when we went for judicial review, we won on that, and we kept winning on that. And so every single client where we ran that argument, and believe me, we ran that every single time for every client until they changed the portal to add those words, all those clients automatically win. Well, some were put on hold, waiting for the courts to make a decision, but many just won. And those clients won because we didn't have to do all the work. In those cases, the director of Safe Roads reached out to us and said, "Hey, we saw that you raised this issue. It's already been decided by the courts. How about we consent to the judicial review and we cancel the NAP or we send it back for a new hearing?" In those cases, the client wins their judicial review, but since we didn't have to do all the work, we can send them back some money. Now, just be aware, if I've already written the memorandum, you're not getting anything back. That was the bulk of the work that I had to do. The oral argument, I'd almost pay to do it. I have so much fun doing it. But if you're one of the lucky ones and the director reaches out or we reach out to the director, and it's happened both ways, and we agree, well, you may just win your judicial review at a bargain. So, it is important that the lawyer is keeping current with the state of the law on judicial reviews, because a case that won on that particular issue could be decisive in your case, and that might mean you don't have to wait a year until your case is heard, because if it raises the same issues as in the other one that won, well, you win. Unless, as they have been doing lately, they go to the Court of Appeal to see if they can have that overturned. One interesting thing is that if you are unsuccessful on judicial review and on a very significant point where we think perhaps the court didn't quite get it right, there is still another option, and that is a right of appeal to the Court of Appeal of Alberta. That is the highest court in the province. Normally, in summary conviction proceedings criminally, you have to request permission to appeal to the Court of Appeal of Alberta, but not in judicial review. That's very exciting. I should say that's exciting for your lawyer. That is not exciting for you, obviously, because that would mean you had lost your Safe Roads appeal and you lost your judicial review, or you won your judicial review and the unhappy director of Safe Roads decided to appeal it. Either way, you're not happy, but your lawyer is very keenly interested in the file. And please be aware that the director doesn't appeal or try to appeal every time the defense wins a judicial review. It's actually quite rare. By the same token, it's pretty rare that the defense will go to the Court of Appeal after having lost at the IRS stage and the judicial review stage. Back to judicial review. So if we go for judicial review, what are the possible outcomes? This is important. We already discussed one possibility, which is where you kind of win by default. Someone else won a file that raises the same issues as in your case, and poof, you win. That's a nice one. Or you could go through the whole judicial review and win, but there are two ways of winning. The notice of administrative penalty can be quashed outright, or the justice may say, we agree that the decision of the adjudicator is not reasonable, but we're sending it back to a different adjudicator to decide the issue given this new direction that the court is giving on this particular point of law. That's less helpful, but it's still a win. The other possible outcome, of course, is that you lose. And at that point, one thing to keep in mind is your situation will not get worse as a result of having gone for judicial review. So, for example, they won't all of a sudden charge you criminally, or they won't increase the penalty. The only thing that will change after having lost the original appeal is that you're now out the legal fees that you paid for going to judicial review. Otherwise, your situation stays the same. You may be wondering as well about costs. In civil proceedings, and these are considered civil proceedings, we have a saying, costs follow the cause, which could also be described as, to the victor go the spoils, which usually means that if one party wins, they usually get costs. That means they get some of their fees back that they had to spend to get their victory in court. In judicial review, it is different. Normally, neither party is seeking costs. We would normally like to seek costs against the director, but the director benefits from something called tribunal immunity. That means that as an administrative board, they were kind of dragged into this litigation. They didn't start it, and they are a somewhat unwilling participant. For those reasons, the court has been reluctant to order costs against the director. The director does not seek costs against us, generally because they don't want costs sought against them, and usually it's a bit of a quid pro quo situation. There are exceptions, and I am not shy about asking for costs in different situations. I just recently did that in an IRS stage that went up to the Court of Appeal, where it was the director who appealed, and I said, why should tribunal immunity apply? After all, the unwilling participant here is my client. The director was the one who started the appeal. We got dragged into the Court of Appeal, and therefore, if we are successful, which I'm still hoping we will be, we should get costs. You can always ask me about how that case went later. Right now, I'm still waiting for the Court of Appeal to get back to us because, as you know, these cases take a lot of time to get decided. Another answer from the courts that we are still waiting on is, can you recover the cost of ignition interlock if you were forced to use it while waiting all that time for the courts to make a decision? If you were refused license reinstatement pending review, and while waiting for your judicial review to come up and be decided you had to use ignition interlock in the meantime, there is a possibility, and it has been argued but I don't think yet decided, that we should be able to recoup those ignition interlock costs. Be sure to ask your lawyer about license reinstatement pending review. You might be able to get it if there is some reason you can't take advantage of ignition interlock instead. So, if you live on a farm and you can't put ignition interlock into your tractor, or your job requires you to drive a fleet of vehicles, or you're constantly hopping in and out of other people's vehicles, if you fall into one of those categories, you might be a good candidate for license reinstatement pending review. If you don't, you can always try and use ignition interlock in the meantime, and maybe depending on how the law goes, you might be able to recoup those costs. Either way, what happens to your license pending this judicial review is definitely something you have to talk to your lawyer about. Now, after hearing all this, you may also be thinking, what makes a case good for judicial review? Maybe you're thinking, there was nothing special in my case. I was stopped by the officer. I blew over. He gave me paperwork. Kind of end of story. There's nothing exciting or special that would make this the next blockbuster legal spaghetti western. Or is there? I had a client who was driving along with a passenger and the road was icy. They slipped off into a snowbank and got stuck there. A nice, or maybe not so nice, passerby stopped, gave them some time to warm up in his car, and in the meantime called police. Police got there, my client blew twice, and then was let go. And you might think, well, there's nothing very exciting there. Aha, but we asked for the audio and video recordings in that case. We asked multiple times. We never got any answers, of course, and we also did not get the audio and video recordings. And guess what? The justice on judicial review said, hey, someone should have responded to all those requests, and they should have got the audio and video recordings because they are the best evidence there was. Isn't that fabulous? Oh, we were so excited. That was the one where our client was jumping up and down at the same time that we were. Another example, I had a client who got a notice of administrative penalty based on a failure or refusal to provide breath samples. That's because he couldn't. He had COVID. Not just the easy kind of COVID that you get over that's a little like a bad cold or maybe even not even a bad cold. No, he got the really yucky kind. He was hospitalized like 3 times. He kept getting COVID, or maybe he just never got over it. In any event, he was in rough shape. He had to have his girlfriend tote around his tools for him. He couldn't sleep lying down. He had to always be on an incline. Otherwise, he felt like there was this huge weight pressing on his chest. And of course, he had tons and tons of medical documentation to show that this was a real thing, and the adjudicator upheld the nap. What a pain. Anyway, we went to judicial review. Well, actually, that's one of those cases where we didn't go. I did a check-in a little bit before our memorandum was due, and I realized he had a good argument that had already been favorably decided for the defense by the Court of King's Bench. And you know what it was? The photographs of the screening devices were not signed by the officer, and there was no statement saying that they had not been altered in any material way. Yep, it had really nothing to do with his health issues, but it had everything to do with winning, and that's how we did it, at a great price point. What these examples have in common is that your first glance at that case may not reveal its full potential. To actually figure out whether or not there's a winning argument buried under there somewhere, you have to go beyond just looking at the surface and really examine the fundamental tenets of the decision. A few good blows at the root of the decision will bring down the whole horrible tree. It's all how you look at it. Those first facts can be rather distracting. The circumstances of the accident or the very obvious health issues can, if you're not careful, almost become a red herring and distract you from the real argument, the winning argument. What you see on the surface is only part of the story. It's all about looking in that special way with our legal eyes. Thank you so much for joining me today. I'm Shannon Gunn Emery, signing off.